All rise. Ladies and gentlemen, the Court of Civil Appeals is now in session. May God bless the state of Alabama and this honorable court. Please be seated.
Good morning. The court is convened today to conduct oral argument in appeal number CL 2025-0419, which is currently entitled the Alabama Department of Public Health and Scott Harris versus Oasis Family Birthing Center, LLC, et al. The members of the court, to my immediate right is Judge Christy Edwards. To my immediate left is Judge Chad Hanson. To my far right is Judge Matt Friday. To my far left is Judge Ben Bowden, and I'm the presiding judge, Terry Moore. The clerk of the court is Seth Rodebeck. I think you've all probably met him by now. The court has reviewed the stipulated facts, the judgment of the Montgomery Circuit Court, and the brief submitted on behalf of the parties, as well as the amici brief filed on behalf of the Alabama Hospital Association, the Medical Association of the State of Alabama, the Alabama Board of Medical Examiners, and the Alabama Board of Nursing. The court understands that this appeal involves a question of law, whether the Alabama Department of Public Health, which I may call the State Committee of Public Health now from time to time, being interchangeable, has the authority to regulate freestanding birth centers using the midwifery model of care. Section 22-2122 of the Alabama Code provides that no person shall establish, conduct, or maintain any hospital as defined in Section 22-2120 without first obtaining the license provided in this article. Section 22-2128 provides, in pertinent part, in the manner provided in this section, the State Board of Health, with the advice and after approval by the Advisory Board, to have the power to make and enforce and may modify, amend, and rescind reasonable rules and regulations governing the operation and conduct of hospitals, as defined in Section 22-2120. Section 21-2220, in turn, defines hospital, in pertinent part, to include, quote, other related healthcare institutions when such institution is primarily engaged in offering to the public generally facilities and services for obstetrical care, which is the statutory language at issue on this appeal. We understand that in 2022, Dr. Scott Harris obtained an opinion from our Attorney General that freestanding birth centers are in fact hospitals subject to licensing and regulatory authority by the Alabama Department of Public Health. The Department of Public Health, in turn, promulgated rules and regulations relating to the operation of freestanding birth centers that were finalized, I believe, in October of 2023, that are now contained at the Alabama Administrative Code 420-5-13.01 2.19. The Oasis Family Birthing Center and the other appellees commenced the underlying proceedings to, among other things, challenge the authority of the Alabama Department of Public Health to make these rules and regulations and to require them to obtain hospital licenses. Specifically in their complaint as last amended, the appellees assert, quote, because a freestanding birth center operating under the midwifery model of care is not engaged in offering obstetrical care to the public generally, it does not fall within the Alabama Department of Public Health's hospital regulatory and licensing authority. The complaint sought declaratory and injunctive relief on the basis that the Alabama Department of Public Health exceeded its statutory authority by purporting to regulate all freestanding birth centers as, quote, hospitals. On May 7, 2025, the Montgomery Circuit Court issued a summary judgment, an order declaring the administrative regulations adopted by the Alabama Department of Public Health to be invalid as to, quote, freestanding birth centers providing midwifery care, because in its opinion, those freestanding birth centers do not provide, quote, obstetrical care and are not, quote, offering care to the public generally, and therefore do not constitute hospitals under Section 22-2121 as a matter of law. Therefore, the order says, they are beyond the scope of the Alabama Department of Public Health's statutory authority to license and regulate hospitals. The order further enjoined the Alabama Department of Public Health and Dr. Harris from, among other things, requiring freestanding birth centers operating in the midwifery model of care to to seek and obtain a hospital license under Section 222122. This order was certified as a final judgment pursuant to Rule 54B, and the Alabama Department of Public Health and Dr. Harris timely appealed to this court. I believe, and I want y'all to correct me if I'm wrong on this, that the parties agree that the judgment is void insofar as it purports to grant declaratory and injunctive relief against the Alabama Department of Public Health, which enjoys sovereign immunity. Am I right about that? If that's correct, and nobody's correcting me, therefore this court will dismiss the appeal filed by the Alabama Department of Public Health. However, the appeal filed by Dr. Harris remains intact. Will the attorneys representing Dr. Harris please introduce themselves at this time?
Hunter Sims representing Dr. Harris.
Benjamin Albritton representing Dr. Harris.
And now will the attorneys representing the appellees introduce themselves?
Good morning, Your Honor. Whitney Lee White, representing all plaintiffs appellees.
Allison Molman, representing all plaintiffs appellees.
Bobby Siegel.
All right. We chose to conduct oral argument today in this venue. As normally we're across the hall in the William J. Thompson courtroom to conduct oral argument, but we wanted to do it here today because the Court of Criminal Appeals has recently invested a ton of money into retrofitting their courtroom for the excellent sound system, and also to give access to the ability of the court to and the parties, if they want to use the audio visual equipment to call up statutes or cases or anything that they want to reference during the scope of the oral argument. And we're the guinea pigs. This is the first case that's going to take advantage of all this technology. So if we have to interrupt you to fix something or just bear with us, this is our first time using it. But with that, I think we're ready to commence oral argument. So if you will.
Presiding Judge Moore, judges of the Court of Civil Appeals, may it please this court. This case concerns whether the Department of Public Health has the authority to regulate freestanding birth centers, which operate under a midwifery model of care, as hospitals under Alabama Code 22-21-20. It should come as no surprise that the department is regulating these facilities as they previously did so from 1987 to 2010. And Alabama is not alone in this effort, as 41 other states also regulate freestanding birth centers. Despite this evidence, the Circuit Court improperly enjoined the department from requiring the plaintiff's birth centers to attain a hospital license, principally on the grounds that only practicing physicians can provide obstetrical care. Currently, the facilities are operating without any state oversight, and the department has been prevented from ensuring the health, safety, and welfare of those that utilize the birth centers. I'd like to begin by talking about how midwifery fits into the larger category of obstetrical care. So as you'll remember, the relevant hospital definition provides that an entity must be engaged in obstetrical care. Obstetrics is not the term at issue. We stipulated to the definition of obstetrics because that was provided in the AG opinion. But this court must decide the scope of the term obstetrical care, considering different words like obstetric, obstetrics, and obstetrical. Our argument is that obstetrical care is much broader than just the obstetrics. Certified nurse midwives, certified professional midwives, and doctors, specifically OBGYNs, all fit within a larger category of obstetrical care. And as our brief pointed out, we see that in numerous areas, the midwives and the doctors' scopes of practice overlap. OBGYNs just have an additional ability to perform surgical procedures. We also see the connection in the midwifery statute, where professional midwives are banned from performing some, but not all, obstetric procedures. I'd like to point this court to the definition of obstetric, which points to a much broader idea of obstetrical care. In Merriam-Webster, the word obstetric means of or relating to or associated with childbirth or obstetrics. And if you take the Latin meaning that word originally comes from, obstetric, it can actually be translated directly to midwife or midwifery. So that's our principal argument, is that obstetrical care is a broad umbrella term concerning caring for women during pregnancy at birth. So it encompasses OBGYNs and it also encompasses midwives. And that would agree with the conclusion in the Attorney General opinion. And that opinion is found in the record at 1723. And their final conclusion was a freestanding birth center is engaged in offering obstetrical care if it concerns the management of women during pregnancy, childbirth, and the puerperium, which is the period 42 days after birth. So that's the principal argument. But second, even if this court relied only on the stipulated definition of obstetrics, these birth centers would still meet that definition. So the stipulated definition simply adds the term branch of medicine to what was previously discussed. So a branch of medicine that concerns management of women during pregnancy, childbirth, and the puerperium. The amicus brief does a really good job talking about the difference between the practice of medicine and a branch of medicine. If you look in their brief, they provide a couple definitions for medicine, and you see how broadly medicine is defined. Merriam-Webster defines medicine as the science and art dealing with the maintenance of health and the prevention, alleviation, or cure of disease. And then Tabor's, which is the same medical dictionary used by the AG opinion, defines medicine as the act of maintenance of health and prevention and treatment of disease and illness. So midwifery would certainly fall into this broad understanding of branch of medicine. And I would also remind the court that the scopes of practice for midwives includes things like prescribing medications, administering medications, and ordering laboratory tests. That certainly sounds like a branch of medicine.
Let me ask you a question about that phrase, obstetrical care, that's contained in 22-2120. It appears to me that that's been on the books since about 1949. Is that right?
Yes, Your Honor.
And there's never been any case that I could find where it was actually defined. Is that right? Not in Alabama.
Not that I can recall.
Has there ever been an administrative regulation that's defined what that means, either it's promulgated by the Department of Public Health or otherwise?
We have not.
So other than this Attorney General opinion, there's no legal authority defining exactly what obstetrical care means
No, Your Honor.
within the context of that statute.
No, Your Honor.
Now, you said that the department has previously was regulating freestanding birth centers. Did I understand that correctly?
That's correct.
So the legislature knows that there's been freestanding birth centers in Alabama since at least the 80s, right?
Yes, Your Honor.
And then this predated them. This language predated them by some 30 years or so. Could they have been referring to freestanding birth centers when they were defining what hospitals are?
Well, I would say I would take the definition of obstetric, and so if you take obstetrical care, they might not have known about freestanding birth centers, but they would know about the practice of midwifery. So midwifery fits into obstetrical care, even if they didn't know about the ideas of freestanding birth centers in 1949.
Well, most, at least common knowledge to me, is that midwives would assist with births mainly at homes of the patients, right?
Yes, Your Honor.
Was there any institutions where a bunch of midwives got together and said we're gonna deliver the child at this institution in a home-like environment or whatever, and that will be within the context of a freestanding birth center or whatever they called it? Was there anything like that back in the 40s when they drafted this statute?
I do not know about the 40s, Your Honor. I mean,
Well, what else could they have been referring to? I mean, there's OBGYNs back then
right.
that had offices like physician offices, but to institutions primarily engaged to obstetrical care, other than freestanding birth centers, what could it possibly be referring to?
Well, we would say that it's a catch-all, so they list out the specific hospitals. And then to ensure that the department can regulate the facility as opposed to the practice, they provided that catch-all, as you'll see, other related healthcare institutions when primarily engaged in offering obstetrical care. So they anticipated the unknown, in our opinion, and birth centers have now entered into that catch-all provision.
So one of the arguments that the appellees make is that because the freestanding birth centers are now fairly common across the country and even in Alabama, if the legislature really wanted to regulate them or give the department the power to regulate them, it so provide. I guess what your response is, well, it already provides.
Precisely. There's no need to add it when it's already covered by the obstetrical care provision.
Right, I guess that gets a bit, we don't really have legislative history in Alabama, and I was just trying to see if there was any indication of what that term meant at that time when it was originally enacted, but I'm not hearing that you have any
And I don't
information.
have the definitions of obstetrics or obstetric at 1949, but I anticipate that if you had your hands on those dictionaries, it'd be similar to what we stipulated. Obstetrics would be something like the branch of medicine concerning, and then obstetric would be very general, talking about related to childbirth.
All right, I'm sorry to interrupt you, but go ahead.
Oh, no problem. So just to kind of recount what we just said, it's a twofold argument on obstetrical care. One, first, principally, that obstetrical care is the broad umbrella term generally relating to childbirth, and the midwifery model fits into that. But then, as I just showed, second, midwifery also meets the stipulated definition of obstetrics in our stipulated facts. Let's move briefly to discuss the public generally component. The department thinks plainly that these birth centers are open to the public generally. The birth centers advertise to the public, they hold themselves out for mothers to use their services and accept anyone who meet their criteria. Plaintiffs argue that because they screen out certain patients that they are not open to the public. But should this court agree with that conclusion, it is difficult to think of any hospital that cannot come up with some type of limiting factor that takes them out of the hospital definition. For instance, there are certain hospitals devoted only to orthopedic surgery. Are they not open to the public generally because they do not accept patients in need of heart surgery? Under their reading of public generally, that orthopedic surgery is not open to the public. The very nature of midwifery is to only serve low-risk patients because they're not potentially in need of a surgical. They cannot use this fact to somehow say that they're not open to the public generally when they're willing to serve anyone who meets their criteria. I'd also like to talk about the question of why can't just the midwifery board regulate this, as opposed to, and why does the department need to regulate these institutions? Simply put,
Before we get to there, let's talk real quick about the offered generally to the public. What's the line?
Your Honor, it's hard for me. We would say that you need to give the term its unambiguous meaning. And I know because they talk about surplusage, and like it's not necessarily under our definition, it wouldn't have any type of meaning. But I would point this court to a case, the Supreme Court Ex parte Triad of Alabama, that's 396 Southern 3rd 191. And that talks about that this idea of avoiding surplusage is not absolute, and applying this rule of surplusage is inappropriate when it would make an otherwise unambiguous statute ambiguous. So we would argue public generally should be given its ordinary meaning, and that's what the legislatures wrote. What that line is, I can't.
Can you give me an example of a time that the department would have determined that a facility providing some sort of, health care was not open to the public?
I cannot give you an example of that, but we've only regulated three. My understanding is it's only 3 or 4 institutions that are regulated under the catch-all provision.
Let me ask you this. You mentioned orthopedic surgical facilities, but you kind of have a level of generality problem in the example that you gave. Of course, they're not going to provide cardiac services there. That doesn't mean they're not open to the general public. The better example would be an orthopedic surgery center that says we don't take high risk, difficult cases. We only do very, very simple procedures here. Is that still open to the general public? If they don't take most of the orthopedic or a lot of orthopedic cases, they limit it to only a certain kind of orthopedic case, one that's that can be done fairly easily?
We would say yes. If they're willing to serve anyone that meets their criteria and whatnot, then yes, they would be open to the. So briefly back to what I was discussing.
What would be not open to the public?
Well,
I'm truly interested in your answer here. And that's why I was asking for if you could think of an example of a time that the department had determined something wasn't open to the public.
I can't speak to. I don't know if they've made that determination as to an institution, but I would remind the court that it's possible public generally was put in there to distinguish between private offices of physicians or dentists, which are excluded from the rule. So maybe public generally is kind of pointing to a difference between those and then the private offices. But as for the line.
What do you mean by private office?
If you look at the end of the definition there, private offices of physicians or dentists are excluded from the definition of hospital, and those fall into the purview.
So like if they had a separate building where they just conducted all administrative type work, or that, I guess I'm confused on what it means by private office. Like the office within their facility,
Oh, no,
an office where the practice of dentistry is not happening, it's just their private administrative office?
no, it's just referring to like whoever your private doctor is. Like if it's their office, then that falls out of the agency purview and then the examiner takes over. That's not an issue here because these are all run by, it's stipulated that midwives are running it. Although OBGYNs are the directors, it's midwives providing the care. So that last part is not at issue.
So anything that's not a private office of a physician or dentist, that's the language that wouldn't necessarily, by your definition, be open to the public.
Yes, Your Honor. That would be we would say public generally is not ambiguous and to give its ordinary meaning.
Doesn't mean that anybody who walks in the door automatically is going to be entitled to treatment.
Correct. But the stipulated facts make clear if they meet their criteria, the birth centers will serve them. And that's borne out in the facts.
Mr. Sims,
Yes.
are the services provided at the birthing center exactly the same as the services provided for home labor and delivery? Is there anything at the birthing center provided that is not provided when the delivery happens at home?
I do not think there's necessarily a major difference in the model of care. I know they'd be staying overnight, I guess, in the birth center. But we just kind of point to the difference, and the amicus brief talks about this. When someone chooses to have a midwife come into their home, they're kind of accepting the risk, and like they take the environment as it is.
But 34-19-16 says that the services can be provided at a setting of the client's choice. So why can't the client choose to have this, if it's the exact same services, why can't they have it at the birthing center as opposed to at their home? If the same services are being provided, why aren't you saying the home becomes a hospital when those services are provided there? What is the difference that makes it a hospital when it's exactly the same medical services being provided at home versus the birthing facility?
Well, we would say, again, once you hold yourself out to the public, that's what makes it a hospital. And I would point you to the definition of birth centers that ADPH used in the regs. And this starts at C 112. So a birth center per ADPH is a publicly or privately owned healthcare facility, place or institution, skip a little word, non-emergency births are planned to occur away from the mother's usual residence. So once they step out in the public and hold themselves out and advertise, that's when we believe they fall into the hospital definition. And the services, while they may be the same, that gets into the midwives and the actual services, but ADPH is concerned with the facility.
And you get some help from the definition where it says other related healthcare institutions when such institution is primarily engaged in offering to the public generally. Facilities, a home is not.
Correct.
So a home would not fit within this.
Yes, Your Honor. And that's what
Mr. Sims, I have one question for you. You mentioned in your opening that obstetrical care is kind of a broad category, correct? So, if you're a midwife practicing as a CNM or CPM, in one of these birthing centers, when do they cross the line into practicing medicine? I mean, is it your contention they're committing felonies at this point?
no, Your Honor. And again, I don't want to speak for examiners because that would fall under their purview, but I talked about the difference between a branch of medicine and the practice of medicine. So what that line is for examiners, I'm not sure, but if you take the ordinary meaning of medicine, we believe it's broad. So nurses or midwives that are doing this type of care are in the field of medicine, but not necessarily practicing medicine.
Let me piggyback on something that Judge Bowden asked you, and that's 3419. Can you pull that up? 341916. Is that that's the statute you just quoted, Ben?
Yes. 3419.
All right, the very first line. Can you read that for me? It's way far away from me.
Yes, a licensed midwife may provide midwifery care in the setting of the client's choice except a hospital.
Except a hospital.
Right.
If you're correct that a freestanding birth center is a hospital, then a midwife can't practice midwifery care there, according to that statute. Is that right?
That is not right, Your Honor, because remember that in the department's statute, hospital is defined. We're not arguing a freestanding birth center meets the ordinary understanding of hospital. We're arguing that it meets the definition of hospital in 22-21-20. That hospital definition would be the commonly understood hospital.
So the department's position is that the word hospital means different things in different statutes.
Yes, it is. Because again, the hospital is not defined in the midwifery statute. So the definition governs the
general.
the definition governs the issue at hand. But since it's not defined there, you'd give hospital its ordinary meaning.
Because y'all aren't taking the position that you can't have a freestanding birth center that offers midwifery model of care, are you?
No, we're not taking it.
But in 2017, the legislature passed this pretty comprehensive act regulating midwives, right? It doesn't say anything in there in that 34-19-11, et cetera, et cetera. It doesn't say anything in there about freestanding birth centers per se, does it?
Not specifically, no, Your Honor.
And it also says in the statute that the midwives themselves are to be regulated by the Board of Midwifery, is the way you pronounce it.
Yes, Your Honor.
Why can't the Board of Midwifery be the one responsible for regulating freestanding birth centers?
That's the point I would like to make, is if you look at 34-19-14 to before, and I've got 14 seconds, so I don't know if I can finish this.
Yes, please.
But if you actually look at, let's get him get this up.
Go back one. There you go.
There you go. So like if you look at section A and you actually look at what the Board of Midwifery can do, again, they can only go at the practice of midwifery. They do not have any type of hook to get to the facility. That's where the hospital definition comes in. So the department can regulate. I had listed things like the facility's governance and administration, qualifications and continued training, physical building requirements, equipment maintenance and quality control. That's the kind of things that the department can do as to the facility. The midwives can only take action towards the practitioner and their license. So if something wrong happened in the facility, the department could revoke the hospital license, but the Board of Midwifery or the Board of Nursing would have no authority over the facility. They could just take action towards the practitioner.
Getting back just very quickly to, is it 34/1916, the hospital? That the position that you're taking is the same position the Attorney General took, correct? In the AG opinion, that
That's correct.
hospital here means something different than the more technical, detailed definition.
Correct, Your Honor.
Any further questions?
Thank you.
Good morning, Your Honors. May it please the court. This case involves a narrow question of statutory interpretation. Are freestanding birth centers hospitals under Section 22-21-20 of the Alabama Code? If they are not, defendant Dr. Scott Harris, in his official capacity as state health officer, is overstepping the boundaries of his authority by attempting to require them to be licensed and regulated as such. Freestanding birth centers employ licensed midwives to provide low intervention midwifery care to low risk pregnant women. The parties agree that these birth centers only fall within the hospital definition if they are, quote, primarily engaged in offering to the public generally obstetrical care. The only conclusion that's consistent with the plain text of the statute, with other parts of the Alabama Code, with basic canons of statutory construction, and with the undisputed facts in this case, is that birth centers are not hospitals under that definition for two independent reasons. First, they do not provide obstetrical care. Obstetrical care is a branch of medicine, and under Alabama law, only physicians can practice medicine. Second, they do not offer care to the public generally, but instead offer care to only a subset of pre-screened, low-risk pregnant women based on screening processes and the exercise of discretion. I'll spend most of my time today addressing these 2 points, but I first want to clarify what this case is not about. This case is not about whether midwifery care in birth centers will be subject to state oversight. It already is, and it will continue to be, no matter what happens here.
Who oversees the facility then?
So the Board of Nursing and the Board of Midwifery have authority over the licensed individuals. It's true that they don't license the facility itself, but this is the exact same model of care that exists, for example, in office-based surgeries.
Okay, so my question is this. If in fact the birthing center does not meet the definition of hospital under subsection 20, then the facility is unregulated by any authority.
The facility is unlicensed. I wouldn't agree that that means it's unregulated. And that's because national standards of care, which are incorporated by regulation into the standards that the boards are charged with enforcing, set basic standards for safety and care for midwifery care. So in the context of out-of-hospital care, midwives have to ensure that they're operating in a safe and clean and hygienic environment, someplace with enough space to safely attend to birth, to safely care for mother and baby, with adequate emergency plans to ensure that there's a transfer if something goes wrong. And those are already incorporated into regulations. So if a midwife is operating in a substandard facility, the board would be able to take action against the midwife for that. And that is exactly the same as what happens in office-based surgeries. There is no regulation of the facility, no regulation about what a doctor's office that provides surgery has to be equipped with, or the width of their hallways, or anything like that. But the Board of Medical Examiners has charged individual physicians with the responsibility for ensuring a safe and clean environment. And they can take disciplinary action up to and including suspending the license to practice or revoking it entirely. So as we've been discussing, these boards do already have oversight to ensure that the care midwives is providing in birth centers is safe, and to ensure that midwives are complying with both Alabama's specific law and national standards of care. This is the background norm in Alabama. The system that the legislature has set up is one in which the boards have regulatory authority and oversight in every setting in the state where healthcare is practiced. But the Department of Public Health only has licensing authority over facilities that meet the definition of a hospital. So there are many examples where healthcare is provided, but it's the boards that are doing the oversight, and the Department of Public Health doesn't have a role. That includes office-based surgeries, as we just discussed, as well as home birth care, which the facts in this case make clear is exactly the same as the midwifery care being provided in freestanding birth centers. It's the same low intervention physiological birth and the same low risk patients in the home birth context as what freestanding birth centers are doing. So again, the department plays no licensing and regulatory role here. That doesn't make the healthcare unregulated.
Ms. White, Mr. Sims says he thought that there was the potential for the mother to spend the night at the birthing center. Is that correct? That there might be overnight stays?
It's true that sometimes labor does last more than 24 hours, and so an individual might be in the birth center for more than 24 hours. The general standards for birth center care include early home discharge. So you wouldn't have someone like in a hospital birth. Oftentimes the mother might stay a night or even two after delivery. That's not the standard practice in birth centers because these are uncomplicated labors and deliveries. There's usually not a necessity. Birth centers usually will follow up with home visits to check on mom and baby in the days after delivery. Ultimately, this is a question that the legislature gets to decide. It has set up a system of regulating healthcare in Alabama that relies first and foremost on the oversight of the boards to ensure that licensed professionals are abiding by standards of care for safe healthcare. And the legislature has in the past amended that definition to be explicit when it wants to make sure that new facilities fall within its terms. They could do that with freestanding birth centers here, but they haven't. So we're not disputing that if the legislature wanted to decide that the department should license freestanding birth centers, it could do that. But we are arguing that under the plain text of the statute as written, and the way it needs to be enforced right now, the scope of the statute simply doesn't reach this care. I want to also just briefly note that I think for more than a year and a half now, the plaintiff birth centers have been providing safe care to Alabama families. And I just want to underscore that this is especially critical at a time like this when the department agrees there is a serious crisis for maternal and infant health in this state and where moms are really struggling to access care. And so the stakes of, I just want to raise the stakes of what is being decided here. These birth centers are trying to be part of the solution. And by enforcing the plain terms of the statute, it will also ensure that this critical care remains available.
How many birth centers are there in the state of Alabama?
At the moment, there are only 3.
And they're in Huntsville and Birmingham, and where's the third one?
The third one is in Gainesville. That's not in the record. It opened after the trial court's decision in this case.
Thank you.
I'm going to spend most of my time on the specific statutory question, but before I dive into the meaning of obstetrical care and the meaning of public generally, there are a few things I wanted to address from the court's colloquy with Mr. Sims. So first, there was discussion about the AG opinion. That opinion concluded that freestanding birth centers might qualify as hospitals if, as a factual matter, they're providing obstetrical care. I don't think that opinion concluded that all birth centers, by nature of calling themselves a birth center, are necessarily hospitals. So I did want to clarify, I think the AG opinion is completely consistent with our arguments. It's a factual question about whether the care happening in birth centers is obstetrical care. Plaintiff's position is that it's not, it's midwifery care. The other point I would raise is about the statute referring to midwives being able to provide care in any setting except a hospital. I agree with Mr. Sims that doesn't apply to preclude midwives from working in birth centers. The AG opinion concluded that because the use of the term hospital there doesn't incorporate this particular definition in section 22-21-20, that should be interpreted as sort of the layperson's definition of a hospital, meaning sort of an acute care hospital.
So y'all are in agreement then?
We're in agreement about that. Let me see. So the last thing I wanted to address was a question about the origins of this hospital definition. As Your Honor noted, it dates back to the 1940s. And there's a couple points that I just want to make that I think contextualize why it doesn't apply to facilities like birth centers. First, as Your Honor noted, birth centers didn't exist at the time. Generally, there were home births or there were hospital births. The second thing that I think is important to understand is that obstetrics was a relatively new practice at the time. It only dates from the middle of the 19th century. Midwifery is thousands and thousands of years old. And obstetrics was really emerged as a practice in contradistinction to midwifery. So I think the idea that obstetrical care was referring to midwives is unlikely as a historical matter. The other thing I would say about the statute...
Let me get you to develop that argument a little more. You said that obstetrics as a field of medicine, practice of medicine, developed way after midwifery, obviously. So that when they took the name obstetrics, they were inventing a new practice area that
Correct.
dealt with pregnancy as, what I understand, is more of a pathology or a condition than a natural development. And
Correct.
the distinction between midwifery and obstetrics as a practice of medicine was one basically focused on the mother, and the midwifery focused on the mother and making a good environment for her to herself deliver the child. And then that the midwife was just basically there to quote catch the child, so to speak. And that when obstetricians got involved, it became more that the obstetrician was delivering the baby and they were monitoring the infant and the mother for potential complications. Whereas midwives would, once those two practices started developing simultaneously, midwives would focus solely on low risk, no complicated type pregnancies, while obstetricians would be focusing on complicated births that would require medical training. Is that the distinction?
I think generally, by and large, I think Your Honor has it right. I do think that midwifery has always involved sort of active attendance, not just passively catching the baby, but ensuring that the mother is progressing and helping with movement and other low intervention mechanisms to make sure that labor and delivery continues to progress. And it's always included some initial sort of care for the infant to make sure that they're all right as well. But by and large, I think you have it right. Obstetrics emerged as a field that was specific to the practice of medicine. And this was about doctors saying, come to us to have your babies instead of the midwives. And so I think the use of the term obstetrical care, especially at that time, was very unlikely to refer to midwives.
They were, by using that term, you think that they were signaling a distinction between midwives who were attending births and obstetricians or gynecologists that were actively delivering the baby, and that's
Yes.
why they use the term obstetric care.
Yes, I think they were specifically referring to obstetricians and care provided by obstetricians. And if they had meant to include midwifery as well, I think they would have said midwifery because they were understood to be different at the time. The other point that I think is important about the hospital statute is that when it was originally written in 1949, it essentially only included the catch-all clause. It referred to sanatoria, rest homes, nursing homes, and other related institutions.
Can you start that over? Repeat that
Of
for me?
course. Sanatoria, rest homes.
No, the beginning of your sentence.
Oh, I'm sorry.
Start all over for me.
When the statute was originally written in 1949, it essentially only included the catch-all clause as the entirety of the definition. So it referred to sanatoria, rest homes, nursing homes, and other related institutions when primarily engaged in offering to the public generally the listed categories of care. But so I think when written, the catch-all clause, it referred to hospitals, to regular hospitals that we understand to be open to the public generally because they accept all comers and that are providing sort of a full range of medicalized treatment. Over time, the legislature amended that definition and added specific additional things to it, including a standalone category for general and specialized hospitals. That might make a little bit of the catch-all clause redundant, but the legislature left it there, and it left it there with the limitations on obstetrical care and public generally. It didn't rewrite it to expand it to capture more facilities and things like birth centers.
So the term, just isolated term, obstetrical care, what is that? Just that term alone, if you were just forget the context, what would it mean?
The term obstetrical care refers to the branch of medicine involved in managing pregnancy, childbirth, and the postpartum period. But it's a specific term, it's a technical term, and it refers to a branch of medicine. In Alabama, medicine can only be practiced by licensed physicians. It's a felony for anyone else, including midwives, to practice medicine. So birth centers cannot be engaged in offering obstetrical care unless they are engaged in providing care that constitutes a practice of medicine. And midwifery, as a matter of law, does not. Mr. Sims referred to a few other definitions other than the definition of obstetrics as a branch of medicine. But I want to reinforce that this definition of obstetrics and obstetrical care as referring to a branch of medicine is the best one because it's the one that's most consistent with other parts of the Alabama Code. First, the idea that the legislature has drawn this bright line between the practice of medicine by physicians and all other forms of healthcare by non-physicians, a line it enforces with felony criminal penalties, and that's a line that I think shouldn't be lightly blurred. Second, the legislature uses the term obstetrical care in other statutes to refer to pregnancy care provided by physicians specifically. So there are statutes related to expanding access to obstetrical care in rural areas that specify that they're about care provided by physicians. That's at sections 22-6-40 through 42.
Ms. White, would you mind addressing that part, if I understood it right, of the appellant's argument from 34-19-14C? That's the part of the statute that lists the obstetric procedures that the midwife is not allowed to perform. Yes. So it seems to suggest that what's not on the list would be obstetric procedures that a midwife is allowed to perform. And in other words, it would suggest obstetric procedures are being performed at the birthing centers, mm-hmm. which is the functional equivalent of obstetric care and would be subject to regulation. Can you just address, I believe that was one of the appellant's arguments, and I want to know if you would mind addressing that for me.
Absolutely. So I don't think the best reading of the statute is that in defining these obstetric procedures that midwives can't do, the legislature is sort of silently defining everything they can do as being obstetric also. And I think that's clear, especially if you consider the fact that this statute was passed as part of the 2017 Act, I think colloquially known as Childbirth Freedom Act. That act is also where the legislature created and enacted the definition of midwifery as primary maternity care. So I think if the legislature had wanted to affirmatively define midwifery care as obstetrical care, it could have done that in the provision that affirmatively defines midwifery. And I think it's unlikely that it would have instead kind of done it in this roundabout way through negative implication of this provision that's really about what midwives can't do. I think the legislature doesn't ordinarily hide elephants in mouse holes in that way. And it was all part of the same Childbirth Freedom Act, which at its root was about, for the first time in decades, explicitly authorizing midwives to provide care outside of traditional hospital settings. And so I think if the legislature had intended for, I use out of hospital, not in the technical term, but sort of outside of a traditional hospital, for settings like birth centers to require a license, it very easily could have done that by referencing the reference to obstetrical care in the hospital definition when defining the kind of care that was going to be provided in those facilities. I want to address one other argument that the defendant made about whether something can be a branch of medicine or can be medicine without being the practice of medicine in terms of the felony prohibition on the practice of medicine by those who aren't physicians. I first just want to point out that this is a brand new argument. The defendant has never made this before their reply brief in appeal, and there was ample opportunity to raise it below. We briefed the question of the definition of obstetrics and argued it no less than 4 times in the circuit court. So I do think the court could consider this argument waived for that reason. But I think the more important point is that the defendant's failure to make this argument before now is indicative of the fact that it strains ordinary language. The idea that you can practice a branch of medicine without practicing medicine is splitting a very fine hair. And I don't think that that's how most folks would use those terms. Ordinarily, you can't practice a branch of something if you don't practice the thing itself. So if we, consider an analogy to the practice of law, a tax lawyer might be said to practice a branch of law, but someone who's in a related field but isn't themselves a lawyer, like a paralegal, you wouldn't refer to them as being engaged in a branch of law because they're not practicing law at all. And so I think that that same principle applies to the practice of medicine and the practice of a branch of medicine.
Let me ask you this. A woman is at a hospital having a baby. The obstetrician is in and out. At a point where the obstetrician is out, there's a couple of nurses in there. They're doing things that they would normally do. They're monitoring. They're maybe drawing labs, just things like that. Are those nurses, aren't they engaged in providing obstetrical care?
I think that you could consider a situation like that to be everyone is part of one obstetrical care team. But that's a very different situation than what's happening in birth centers.
Are they practicing medicine?
I would not say that they're practicing medicine.
But they are engaged in the provision of
They're engaged in the provisioning of nursing. You might, in ordinary language, call it part of the obstetrical care team, but that's because they're assisting a physician in the practice of medicine and the practice of obstetrics. That's not what's happening in birth centers. There are no physicians providing care there. It is midwives working within their scope of practice. I think if a nurse was in a nursing facility, working without sort of a physician there, you wouldn't use language in the same thing, in the same way. And so I think, whether we might use language more loosely in the context of a hospital where the physician is there and everything is sort of supporting the physician is different than whether that applies to midwifery when there are no physicians providing care. It is solely the practice of healthcare that they have been authorized by the state to do and that the state defines as not being a practice of medicine.
An individual, a nurse, could be engaged in the delivery of obstetrical services and not be practicing obstetrics.
That's not how I would use the language, Your Honor. But I do recognize that there are sometimes in everyday language a looser use of language than what we would find in the dictionary definition. But I think the legislature is presumed to know the technical meanings of the words. So even if, a woman in the hospital might refer to her nurse as being providing obstetrical care, that doesn't mean that as a matter of statutory interpretation and the technical definition of that term, that it constitutes a branch of medicine when it's a nurse and not an obstetrician.
Let me kind of piggyback on that because is there a distinction between a certified nurse midwife and a certified professional midwife?
There are distinctions in their legal scope of practice. Certified midwives do have a broader scope of practice than certified professional midwives. In particular, they provide care during pregnancy and childbirth. They also provide basic gynecological care, family planning services, can be a primary care provider for women of reproductive age. Certified professional midwives are solely limited to the pregnancy context. So there are some differences, but it's undisputed that they both are engaged in providing midwifery care.
All right. I'm going to read from you a regulation from the Alabama Medicaid Agency regulating nurse midwife program. This is 560-X-21-.05. It says, the maternity services normally provided in maternity cases include antepartum care, delivery, and postpartum care. When a nurse midwife provides total obstetrical care, the procedure code which shall be filed on the claim form is the code for all-inclusive global care. According to the Alabama Medicaid Agency, nurse midwives can and do provide, quote, total obstetrical care, the same basic term used in 22-21-20. If the Alabama Medicaid Agency is of the opinion that nurse midwives are providing obstetrical care, should we consider that as influencing our decision on whether that statute also refers to midwife care as being a component of obstetrical care?
Well, Your Honor, I do think that this is a regulation of a state agency. It's not the legislature's own voice. And this is a question because the definition of hospital and the definition of obstetrical care is a question of the jurisdiction of the Department of Public Health and of Dr. Harris. This is a place where deference to agencies and in their interpretations wouldn't ordinarily be appropriate. It's the court's role to first decide what the statute means, what the legislature's intent was, and to enforce those legislatively set boundaries on the agency's authority. So I recognize that that is a data point that the court can consider, but it's not one that I believe the court should give much weight to.
And then one other point on construing that term. Mr. Sims pointed out that the term obstetrics is derivative of a Latin origin, which it is, and that the term obstetrics in Latin literally means midwife, of or pertaining to midwife. And I don't know in 1949 whether the legislature was using a Latin dictionary when it was used including this term in there, but that certainly is the etymology of the term obstetrics equals midwife. And I know that the current statute says that midwives provide, quote, midwifery care. They don't use the term
Right.
obstetric care, but since obstetric means midwife, isn't midwifery care nothing more than a smaller component of obstetric care?
I don't think so. And again, I think if the court looks to other evidence from the statutory code, the legislature, whether or not there might be this sort of etymology, and this is not an argument I'd heard before today, so it's not one we addressed in our briefing. But what's relevant is how the legislature is using the term obstetrical care in the hospital statute. And when you look to other statutory evidence about how the legislature understands that term, it uses the term obstetrical care in the hospital statute. It uses it in reference to care provided by physicians. And then when it's actually affirmatively defining midwifery care, it's using materially different terms. And the ordinary presumption under ordinary rules of statutory interpretation is that word choice to use different language is a meaningful one, and those words should be interpreted to mean different things. I see I'm running very short on time, and I haven't had a chance to address the public generally prong of the argument, so I'd like to move on to that if that's all right. The trial court concluded that birth centers are also not hospitals for a second independent reason, that they don't provide care to the public generally. The hospital definition lists many categories of care that are explicitly covered, but in the catch-all clause that's at issue in this case, that is specifically limited to facilities offering care to the public generally. You heard from Mr. Sims today that defendants are not able to come up with a single example other than a private doctor's office, which is separately exempted, of a facility that would not be offering care to the public generally under their interpretation of that phrase. And their answer is, even if that makes it superfluous, maybe that's okay. But I don't think that the court should ignore the ordinary rule that the legislature's choice to use a term in one part of the statute, like limiting the catch-all clause to public generally, that should be negated and not be treated as a meaningful legislative choice. I also want to point out that there are Alabama Supreme Court precedents that offer an understanding of what the public generally means. And those cases distinguish the public generally from a discrete class or subset of persons. Under that reasoning, birth centers are serving only a discrete class. It's undisputed that they offer care to only low-risk individuals who have to undergo a rigorous screening. It's undisputed that these patients have to agree to other policies and procedures of the birth center, including patient education, to make sure that they're adequately prepared for an unmedicated out-of-hospital birth. And if midwives have any doubt that patients meet these requirements, they can exercise their discretion to say, we're not going to take you on as a patient of the birth center. That is very much like what private doctors' offices do in deciding, yes, I'll take you as a patient. No, I'm not taking patients right now. It is not what facilities that I think are the quintessential examples of serving the public generally do, which are things like emergency departments, where you can show up without an appointment and be evaluated for care. Now, it's not the case that an emergency department has to be equipped to treat every single conceivable condition that someone might show up with in order to be serving and offering care to the public generally. But it remains the case that you can show up and be evaluated for care without a threshold barrier before you get through the door. I think that's the best understanding of what this term means. With my remaining minute, I just have a few words I'd like to say in closing.
Before you do
course.
that, let me ask you this. Do we owe deference to ADPH's interpretation of Section 222120?
No, Your Honor, I don't believe you do. That statute is one that the legislature used to set a boundary around ADPH's authority. And you can see that in there is a purpose statute attached to the hospital licensing laws. That's at Section 22-21-21. There, the legislature states that the purpose of hospital licensing is to ensure standards for treatment and care of individuals, quote, in institutions within the purview of this article. So the purpose itself is referring to only those institutions that are covered by this chapter, those institutions that are defined as hospitals. The legislative purpose is not to encompass all settings where healthcare is provided. It's not to allow the Department of Public Health to decide in the first instance whether it thinks it's a good idea for a particular facility to be licensed. And in that sort of situation where it's a jurisdictional question, precedent would dictate that it's up to this court to independently determine the statute's meaning without deference to the agency.
What institution would be within the scope of a offering to the public generally obstetric care in Alabama?
In Alabama. I'm not aware of a model of care that currently exists in Alabama that I think would fall within that statute. But I think something like a freestanding labor and delivery unit, something that operates like an emergency department. You can come in without an appointment, and that it specializes in offering labor and delivery services similar to what's offered in a hospital. You could think of a model of care like that being used to help fill some of the gaps in rural healthcare access in a place like Alabama. If they're offering things like C-sections, that would be obstetrical care. It would be operating to the public generally. The last point I want to make, Your Honors, is that ultimately, as I've said, this is a question for the court and a question for the legislature to determine whether or not the department's authority encompasses freestanding birth centers. I think this legal question, for the reasons I've said, is relatively straightforward in that I think basic application of ordinary canons of construction and looking to the undisputed facts about what birth centers are doing leads to the conclusions that they are not hospitals. But I just want to underscore again that these birth centers have been safely providing care for some time now, and their ability to keep doing so does hinge on the outcome of this court's decision. So
Thank you.
Thank you very much.
Just a few things. I'd like to start with the use of the phrase obstetrical care. Council discussed that the legislature would not understand that to include midwives because they used obstetrical care. But we would argue the opposite in that they used this broad term obstetrical care to cover all the areas involving childbirth. And if I remember correctly, they pointed out the practice of obstetrics came around in mid-19th century. So the legislature in 1949 could have engaged in the practice of obstetrics instead of obstetrical care. And Judge Bowden pointed out and what we put in our brief from the midwife statute about they cannot perform these certain obstetric procedures. That speaks to the idea that they can perform others, but again, it also points to how midwives and OBGYNs are connected in obstetrical care generally, in that in a low risk pregnancy, which that's the only pregnancies that midwives have, the practice that an OBGYN or a midwife and the methods they'd use with that patient would be very similar for natural births. And that just, we think that statute kind of points to how connected they are. And then the Medicaid regulation that you brought up, talking again about this broad idea of obstetrical care, that just kind of points to the ordinary meaning that obstetrical care is a broader umbrella-like term. And they point out a ton of times in their briefs and in argument, they're trying to create two categories by saying midwifery model and obstetrical model. But it's pretty simple that there's a broader category, and then within that you can have smaller things. So if I went to the grocery store and someone told me to pick up some chips, that would be the general. But they could also tell me to pick up some Lay's, and the Lay's falls into a broader category of potato chips. It's just like that. I'd also like to speak before we close about the Tucker case, because I believe that's a very important case. And that gets to, that case involved an abortion center that came under the hospital definition. And this court said that in determining whether something is a hospital, you should look at what takes place there. And I want to talk about kind of the difficulties from the rule that the circuit court fashioned, as opposed to, for instance, what the department did in defining birth centers. So the circuit court made a rule based off of the WHO. They said only medical doctors can provide obstetrical care. But the department made a general rule, and again, I'll kind of reread what that regulation said. In defining a birth center, they said it is a publicly or privately owned healthcare facility where non-emergency births are planned to occur away from the mother's usual residence. And then it goes on to speak that birth centers can be run by OBGYNs, they can be run by midwives, they can be run by registered nurses. So Tucker says that the regulation of a facility is the regulation of what takes place there. So a rule like the Attorney General's opinion, the management of women, obstetrical care is the management of women during pregnancy and childbirth, is much simpler to enforce as opposed to some rule related specifically to who is performing the services. Because like you can imagine some gray areas, we stipulated that only midwives can, in the stipulated facts, that midwives are running these two facilities. But what if the OBGYNs were assisting at the birth centers? And how difficult the line drawing would be with them being engaged. Are they engaged in obstetrical care if that OBGYN is now helping? So that's I believe the case that I cited was Norfolk v. Johnson. So that speaks to the idea that when you're determining a meaning for a term, you need to consider the effect. So we would just point out how difficult their line drawing would be under their rule as opposed to ours. And then lastly, I do want to speak about the policy concerns, because that was a big point of all their briefs and access to care and whatnot. So in just about every brief that the plaintiffs filed with the circuit court and in their brief with this court, they've blasted the state of maternal health in our state of Alabama, both in access to care and health outcomes. And the department would respond that they are certainly focused on maternal health and have spent extensive time and efforts to improve the same. And it was with this idea of maternal health in mind that the department enacted regulations to ensure that these facilities, which care for expectant mothers and deliver babies, meet certain standards. If plaintiffs have their way, the only regulation of the actual facility would be from the respective boards regulating the practice of midwifery, but there would be no regulation of the actual facility. So the department would argue that any of these maternal health concerns that they have so frequently brought up would only be made worse by not regulating a facility that delivers babies. So again, into thinking of a rule, we think the Attorney General opinion's rule is a good one to go by. And I'll reiterate exactly what they said. A freestanding birth center is engaged in offering obstetrical care if it concerns the management of women during pregnancy, childbirth, and the puerperium. Any questions?
Sorry. So going back to 21, 20, and I believe Ms. White characterized this last part as a catch-all. And I think that open to the public generally only applies to what's listed in the catch-all. So general and specialized hospitals offering services to the public generally doesn't matter for those. Here's, is that correct?
That phrase applies to the catch-all, yes, but we would point out that it says other related healthcare institutions at the
Sure,
beginning.
sure,
So,
sure.
yeah.
So, but I'm gonna go back to this, include the private offices of physicians or dentists, because that then becomes an exception to the rule. There was obviously a need, the legislature felt a need to create a specific exception to the rest of it. My question to you is, are private physicians' offices, private OBGYN offices, are those facilities regulated?
I don't want to, the examiner statute, I don't want to say something, but we believe that there's a hook for examiners to actually enact regulations on facilities. That's why that, exception is there. Nursing and midwifery
Are
would not.
private OBGYN offices required to be licensed with the Department of Public Health?
No. Not as a hospital, no.
Because you consider them to fall into this catch-all provision.
No, not the catch-all. Private offices.
I mean, the exemption. Sorry.
Yes, Your Honor.
Even though they're performing. I think he's cutting off. Care for pregnant women. I can't say this word. I've never been able to say this word. Obstetrician care. Thank you. Why are they not required to be licensed under 22, 21, 20?
That, again, that gets into this, the legislature pulled them out specifically.
No, the legislature pulled out private offices of physicians or dentists. That's what the legislature pulled out. So you consider them to be the private offices of physicians. I don't know how you square that with other related healthcare institutions when such institution is primarily engaged in offering to the public generally baby care.
So we would say that the exclusion would apply. I believe that's a normal canon of statutory interpretation, that the exclusion would apply over the general catch-all. So obstetrical care, you give it that broad meaning, but if you're having a private office,
So an obstetrician could deliver a baby in its private office and not have to be licensed, but your position would be that these birthing centers do.
well, I would point out that if an obstetrician does that in a hospital, they would be.
No. I asked, my specific question was, you said the exemption would take a private OBGYN office out of the requirement to be licensed under this statute. And my question was, if they perform birth services in their office, just like a birthing center would, are they exempt from the licensing requirement specifically because of this exemption?
If they're considered a private office, they are exempt, yes, but.
I'm having trouble squaring that with, then why would the birthing center in these cases have to be licensed?
Because the birth center is not excluded. We would say the private office is specifically excluded,
Okay.
the birth center still fall under the general. And the medical examiners, again, I don't want to say something I don't know, but examiner statute has hooks to regulate the facility. The Board of Nursing and the Board of Midwifery, we think those statutes are pretty clear. You can only go at the practitioner, not the facility. Anything else?
Thank you.
Thank you.
No questions? All right, that concludes our oral argument. Both sides gave very, very persuasive arguments. We're going to take this case under submission, and we should have an opinion to you, I won't say shortly, but at some point in the near future. Thank you.
All rise. Court is now adjourned.